All right, welcome. In this explainer, we're diving into the EHOs toolkit. We're going to sharpen the most critical skill you have, turning what you see on an inspection into absolutely watertight enforcement action. Let's get into it.
So you know the drill. On one hand, you've got the standard we all train for: clean, controlled, completely compliant. And on the other, well, you've got the reality we find all too often: that moldy wall, that filthy corner. That is so much more than just a bit of bad cleaning. It's a potential legal contravention. Our mission here is to build a rock-solid bridge from what your eyes see in that kitchen to what a court will see as a legally sound case.
You know, it really does all start at the scene of the contravention. The first and honestly the most vital skill is to stop seeing a dirty kitchen and start seeing the specific, legally defined breaches that are hiding in plain sight.
So where do we find these legal definitions? Well, the foundation is something called assimilated law. Now that sounds complicated, but it's really not. It just means that the core EU food hygiene regulations we've all been working with for years, like the big one, Regulation 852/2004, they haven't gone anywhere. They were just brought over and are now fully part of UK domestic law. So good news. The rulebook is one you already know very well.
And knowing your way around that rulebook is absolutely key. The regulations are actually laid out pretty logically. You've got the recital, which kind of gives you the backstory, the why behind the rule. Then you've got the articles, which lay down the big, legally binding duties. But for us, on the ground, the real gold mine, it's in the annexes. That's where you find the specific nitty-gritty standards that we measure everything against.
Okay, let's put this into practice. Check this out. Our first piece of evidence from the scene: a ceiling, paint flaking off right over a food prep area. Now, we all know instinctively this is wrong, right? But what's the exact bit of law it's breaking? Where in those annexes would you pinpoint? And boom, there it is, Annex II, Chapter 2, Paragraph 1C. The regulation couldn't be clearer. Ceilings must prevent the shedding of particles. That's not a suggestion, it's a hard legal requirement. And just like that, we've connected a physical observation to a precise legal reference. That's the first brick in the wall of our case.
Okay, next piece of evidence. This floor-to-wall junction. We've all seen this 1,000 times. It's a classic sign of long-term neglect. You can practically smell the buildup of grease, dirt, and who knows how old food debris. Again, we know it's a problem, but what's the legal hook?
For this one, we go right back to basics. It's a direct hit on Annex II, Chapter 1, Paragraph 1. This is one of the most fundamental rules in the book. The premises must be kept clean. It's a really powerful catch-all standard that this business has clearly and badly failed to meet.
Right. Last example for this section. Look at this, a big unsealed gap around a waste pipe. For any EHO, that's a massive flashing red light. It's basically a welcome mat for pests to just waltz right into the kitchen. So what's the specific contravention we're looking at here?
This is the perfect example of a structural failure. The law says the building itself has to be designed to permit good food hygiene practices, and it specifically calls out pest control. So that gap isn't just a hole in the wall, it's a failure to comply with Annex I, Chapter 1. See? We've now built a clear, undeniable pattern of non-compliance.
So, we've identified the breaches of all these hygiene standards. Great. But a breach isn't quite an offense. Not yet. Now we have to do the legal work. We have to build our case and turn that breach into a properly chargeable offense.
Here's the crucial link you have to remember. The assimilated EU law, our Regulation 852, it sets the standard. It tells us what a clean, safe kitchen is supposed to look like. But it's our own domestic UK law that gives us the power to actually enforce it. The two have to work together.
And this, right here, is the legal linchpin, Regulation 19.1 of the Food Safety and Hygiene Regulations 2013. This is the bridge. It's the piece of law that says, in no uncertain terms, that failing to comply with those EU provisions, the dirty floor, the flaking ceiling we just saw, is an offense under English law. This is the legal switch that gives your findings some serious teeth.
So how do we write this down to make sure it's completely bulletproof? Well, here is a practical template you can use every single time. Look at the structure. First, you state the simple fact, what you saw. Then, you cite the specific breach of the assimilated law. And then, this is the critical part, you state that this creates an offense under our domestic regulation 19.1. This wording is your shield and your sword for any formal action you take.
Of course, the business owner does have a potential way out, the due diligence defense. They can try to argue they took all reasonable precautions. But what's so important to remember is that the burden of proof is on them, not you. They have to prove they did everything they reasonably could. And your detailed notes and photos? That's the best weapon against that claim.
Okay, so we've identified the breach, we've framed the offense, now comes the moment of truth. What are we actually going to do about it? This brings us to choosing the right tool for the job from your enforcement toolkit, using the hierarchy of action.
This pyramid should be second nature for every single EHO. It's our guide. But remember, it's not some rigid ladder you have to climb one step at a time. No, it's all about proportionality and using your professional judgment to pick the right tool for that specific situation, from simple education and advice at the bottom all the way up to a full-blown prosecution at the top.
Now, the pyramid is pretty much split into two different approaches. You've got informal action, things like advice, maybe a warning letter. That's all about persuasion, trying to get them to comply voluntarily. But the moment you cross that line into formal action, like serving a statutory notice, the whole conversation changes. You're not asking anymore, you are legally compelling them to act.
The Hygiene Improvement Notice, the HIN, is one of the most powerful formal tools you have. This thing is not a suggestion. It spells out exactly what's wrong, what needs to be fixed, and sets a hard legal deadline. And don't forget this part. Failing to comply with an HIN is a completely separate offense in itself, which, frankly, can be a much more straightforward prosecution to win.
And then, right at the very top of that pyramid, you have prosecution. This is the ultimate sanction. We save this for the most serious cases. We're talking about situations where there is a significant risk to public health, a complete disregard for the law, or just a long, painful history of non-compliance. This is where all that careful legal groundwork we talked about really pays off.
So let's wrap this all up and look at the real-world power of what you do. Because this isn't just about ticking boxes and filling out paperwork, is it? It's about the direct line you draw from your inspection notes all the way to protecting the health of the public.
Just look at this case, a 20,000-pound fine. Now that's a number that gets people's attention. And that fine is a direct result of an EHO doing exactly what we've just walked through. Spotting a breach, building a solid case, and taking decisive, formal action. That sends a huge message, not just to that one business, but to everyone.
At the end of the day, you should never forget this. Behind every notice you serve, behind every case you build, is the full weight of the law. Your professional judgment, what you see and note down on site, can lead directly to this very moment, a legal decision that upholds standards and, most importantly, keeps the public safe from harm.
So, we'll leave you with this to think about. Your toolkit has both the subtle power of persuasion and the undeniable force of prosecution. As an environmental health officer, thinking about your own work and the businesses you deal with, where does your greatest impact really lie? The secret is in the wisdom of knowing exactly which tool to use and exactly when to use it.